talking today about Local Government 101. This is our take as municipal solicitors and attorneys on kind of the basics, the foundation of where we are, who we are as municipalities, and what the role of the elected officials is when it plays into that. And I know we're not in an election year, so the number of new officials, and we're not in an election year now in 2022, so the number of new officials that will be coming on board is probably going to be a much smaller pool. But as we look forward to 2023 being an election year, I think this is going to certainly be a hot topic, and I assume this program will rerun in later 2023 or at some point early 2024. And the idea that we want to hit on is, what are the basics, the very kind of intro level, what are we as a municipality, where do we fit, and kind of what are some of the key topic issues that every municipal official who's elected or hired as a new manager needs to start to get their arms around as you walk in the door to the municipality. So just a bit about myself. I'm Mike Crotty. I've been with the law firm of Siena Law since 2004. We handle municipal law, and we do it essentially wearing two hats. The first hat is as defense counsel through PIRMA whenever municipalities get sued. So that's townships, boroughs, zoning hearing boards, authorities, and their police departments and everything else. And the scope of what we get sued for is pretty broad. It ranges from anything from trip and falls. We've got guys who handle just that. Labor and employment matters, and I know Andy and Chris Gerber and Sherry Brown in our office handle that. Civil rights disputes, civil rights lawsuits, all the way down to land use zoning and a lot of the regulatory compliance issues that and hoops that we have to jump through as municipalities. The other hat that we wear are as solicitor to a number of different municipalities. So in addition to addressing these issues and getting hit with these issues in lawsuits, we see them firsthand through the township and the borough meetings that we attend, trying to keep our municipalities out of trouble, keep them on that side, off of any kind of a lawsuit caption. I'm here with Andy Rongaus here today, and I'll let Andrew introduce himself.
Thanks. Good morning, Mike. We are also here with Andy Finn, so it does get confusing, even for me. Welcome, everyone. Nice to take some time with you today. As you know, my name is Andy Rongaus. I'm a partner here at Siena Law as well. I come from a little bit of a different background than Mike. I have my experience comes from working for the government in the sense of as a prosecutor, first with the local DA's office. I was also with the Attorney General's office as the Chief Deputy Attorney General. And then before coming to Siena, I was Deputy Chief Counsel for the Pennsylvania State Police. So I do have some background in dealing with all these items that Mike talked about, and municipalities as well. I focus my practice here at Siena basically on, as Mike said, civil rights defense for municipalities and police officers, employment law. I do some solicitorship work with Mike, and then also police department and law enforcement policy procedures and things like that. So looking forward to talking with you guys today. If you have any questions or anything, please shoot them into the comments, and we'll try our best to address them as we go along.
And as Andy mentioned, that's a great point. Ask questions as we go along, because we're lawyers, so we can talk all day and not stop for a minute. So if you do have a question you want us to hit, either put it in the chat or the Q&A, and myself or one of the Andys will try to hit on it. Of course, the advisory stuff up front, we're lawyers, we're talking about legal matters. We are not giving legal advice to you. This is instructional and informational, educational only. Of course, consult with your solicitor and your legal counsel, or with the PIRMA Legal Access Program if you have any particular fact-specific issues that your municipality is facing. So we're going to talk about, again, big picture in terms of the course outline. the first one is, where do we fit in the big picture? That's going to be an overview of local government as part of the government. Andy will then touch on who is the boss, and that'll kind of hit on the idea of what are the different roles of the elected officials, the employees, the consultants, and legal counsel from a legal perspective, understanding that each municipality is a little bit different in how they make that, where they draw those lines. But we'll kind of talk about the kind of the basic structures that are out there and the basic issues that we run into from the lawsuit world when those lines get crossed. Andy will touch on, again, personnel labor being the boss. And I'll, at the end, touch on both the mechanics of running the government, local government. That'll be the parliamentary procedures that we use for our meetings, the Sunshine Act, the Ethics Act, the Right to Know Act, just to briefly touch on some of those. And then we'll wrap it up with a brief discussion about municipalities and litigation. So without further ado, where do we fit in the big picture? If you remember from 3rd or 4th grade social science, social studies, the federal government is based on, of course, the Constitution. As we are in Pennsylvania, we have our own Pennsylvania Constitution. Ours came first, and the U.S. Constitution is actually modeled in large part after the Pennsylvania Constitution. But of course, we're split into the 3 branches of government: the legislative, the executive, and the judicial. And where we are in Pennsylvania, of course, there's that same split. And the unique part about local governments, and kind of here's where we fit kind of on the side, the unique part about local governments is it's not the triangle that a lot of people would make you think it is. We're not under school districts. We're not under counties. Instead, we are our own separate branch of the Pennsylvania government. And we don't, although they have some regulatory authority over us, counties do, we don't necessarily report to them. We're kind of our own entity. And in effect, as we put in the big bold type here, we are all the other branches of the government rolled into one. We're really where the rubber meets the road, because we deal with both roads, sewer, water, stormwater, property maintenance, zoning and land use, ordinance enactment, police, fire, ambulance. We have to deal with all that stuff, and we have to do it where we hold local meetings each month where the community can come right out and praise us or complain to us about things that they think we're doing wrong. How are we all the other ones rolled into one? Well, we're obviously legislative in terms of when we enact ordinances, do our different zoning and property maintenance regulations. We're the executory in that we've got zoning officers and police officers who then carry out those ordinance provisions and make sure to force people into compliance. And we're the judicial. We've got our zoning hearing board, which hears zoning matters at the township level and even borough level for borough councils. We could have conditional use applications where we are sitting as the judge over an application. And if someone doesn't like our decision, they have to appeal it to up the chain in the court system. So we are all those different branches of government rolled into one, which makes for a pretty unique posture of who we are and what we are as local government. As we know, local government, we are creatures of state government. So our authority, we don't have broad-based authority to kind of do whatever we want. And that's what sometimes there's a misconception on the part of newly elected officials who want to do everything. They want to, enact all this new stuff and regulate people a lot more. Because we're creatures of state government, we only have the authority given to us by the state. And that comes down in a lot of different ways, but it also there's a lot of different restrictions that come with it as well. We can't just do whatever we want, even if it makes sense, and even if it's something that everyone in the room wants. We've got a lot of limits on what we do. What are those limits? It ranges from everything to court decisions and case law. And there's a whole hodgepodge of different statutory acts that are out there that limit and constrain what we can do. Of course, on the borough level, we've got to follow the Pennsylvania Borough Code. On the township level, the second class township code, those give you the basic roadmap, but that's not the end of the picture, because there's all this other stuff out there that helps guide where and what we can do. If we jump next to, I think, Andy, you're going to touch on who is the boss at the municipal level.
Yes, thank you. Who is the boss when we do this? We get a lot of questions about this because it varies in different municipalities based upon the way that you set up and organize your government. So ultimately, ultimate power rests with the governing body, which would be the Board of Supervisors or Borough Council. To take a check away from President Truman, the buck stops there. That's where it ends. You have the ultimate authority, but there are also other times where that authority can be given to other individuals within the municipal government. So, for example, in a township where you have a borough manager, a township manager, or a borough where you have a borough manager, some of the day-to-day daily governing and operations, those decisions can be delegated to the borough or township manager. In addition, for example, when you have a chief of police if your municipality has a police department, some of the day-to-day decision-making regarding employment decisions and otherwise can be delegated to the chief of police with there. But ultimately, the borough council and the township supervisors are the ones who have the final policy-making decision. And most importantly for you, if you're in one of those roles, you are the one whose name's going to be on that lawsuit when something goes wrong or someone wants to make a claim against you. The township or borough manager, your chief of police, your treasurer, your secretary, any consultants or experts that you hire, like an engineer, your solicitor, they all can give advice. You can delegate certain authoritative decisions to them. But at the end of the day, all power and all policies and decision-making come from Borough Council or the Board of Supervisors. All right, Mike, you want to jump back in?
Yeah, and one important point to make there is to make sure that everybody knows where those lines are, because Andy and I have both seen where a manager starts to run down the road under the belief that they have certain authority and either have an existing board or council or new council members who don't quite agree with that. And the manager can be taking certain actions to, hire and fire, for example, or sign a contract or submit grants. And I've seen at least, or heard of at least one circumstance where they ended up parting ways with their manager, or a township did, because of grants that the manager was submitting that the board didn't approve, and the board didn't like the manager doing that. So it's important to make sure that those lines are drawn between and kind of delineated between what the manager's authority is and at what points they need to trip and go up to the borough council or the township board of supervisors.
And Mike, that's an important point that you make. We were going to talk about it a little bit later on, but one of the ways that we do that and make sure that we do talk about it is making sure that all those individuals have very specific job descriptions as well as written directives regarding what those policies and decision-making authority that they have. And we'll get into that a little bit more, but yeah, good points.
And then touching on we have our own new official checklist that we give out to each municipality, or we talk about with each municipality. And I know Chris Gerber from our office really was the genesis of this one, and he's a firm believer in it, as we are as well. And the idea is to make sure that through this checklist, everyone's operating from the same book. So typically when there's a new official, there's what we appreciate is a book or binder of governing documents that has your employee handbooks, any kind of employee policies, employment agreements, collective bargaining agreements, the zoning ordinance, the budget, all your basics put into one area so that they can bring that to the meeting. They can look it up if they have any thoughts or if any issues come up during the meeting, but everyone's on the same page, even if they don't read it, but everyone's got on the same page of what are those governing documents and what kind of controls what we do is a borough or a township. And if we need to make changes, where do we start and how do we do it? We also, for new officials, typically have a briefing by key staff, the manager, the solicitor, where we bring in that new official and essentially start from zero. Okay, here's where we are. Here are the issues that are out there that we're facing. Here are some things that are going to be coming up next month. Here's how our sewage treatment plant works, because that's foreign to a lot of people. It might not be foreign to some of us here today, but just a lot of the basics of what does the township do, or what does the borough do? Because as I'm sure a lot of us have faced, there are a lot of times when new officials and maybe even some old officials are in office and they don't have quite a firm grasp on what the municipality does, either because they were the firebrand sitting in the back of the room and complaining about everything, or they're just completely new to and have never attended a borough or a township meeting. Because I'm sure if we took a poll, quite a few of us have experienced that, where we have a new official that no one's ever seen at a meeting. So that person is going to come in fresh. They have a lot of ideas, but we have to make sure that they know ideas are great and we want to carry through those ideas, but there's a whole process you got to do. You got to go through to implement them. And there could be practical reasons and legal reasons why you can't accomplish those things. Again, just not to drive home the point, we've run into so many circumstances where there's that firebrand in the back of the room and they're complaining about everything. Once they're on the inside and once they kind of know both the process and the parameters by which we have to operate as municipality, all those complaints that they had before sometimes slough away and kind of fall by the wayside, and they become hopefully more of a team player.
And Mike, it's important that you in talking about that, and I know that we talk about this for new municipal supervisors or borough council members, but in the litigation that we see sometimes, this is just as important for individuals who have been on council, or as a supervisor before for many years. I can't tell you how many times we get a lawsuit in, and then we start talking to the municipality and the governing body, and we start talking about some of the issues in there. And the lawsuit is around the collective bargaining agreement that you have with the police department. And as you know, the collective bargaining agreement says X, Y, and Z, and I get deer in the headlights from some of the municipal policymakers, and it's like, I've never even looked at the collective bargaining agreement, or it's this policy, and the issue is with this policy, and it's I've never seen that policy before. We have had individuals where the first time that they're being questioned about a policy or a procedure and they see it is in the deposition, and that's bad. That's really bad. So you really need to, as a municipal official, you need to understand what the policies and procedures are. You need to have them. You need to have been able to see them and look at them, because ultimately, as the final decision maker, you are the one who is in charge of determining what policy is. And that comes into play, and we'll talk about it a little bit more later on, where we talk about some of the claims that can be made against a municipality. And that is super important, because under federal law, there are policies and procedures come into question when you get sued for what's called a Monell claim. And that is for, basically not providing the necessary training or going through the necessary background checks or turning a blind eye to things that are going on in your township or in your municipality or borough. So it's very important for you to understand what's going on. I highly recommend to you that if you haven't done it before, that you go back to your municipality and that you get those specific documents. You put them into a binder or put them into a place so that you have them at arm's length, and you can grab them and review them. And if there's any questions about them, start those discussions and get them moving forward. So, Mike, if we move on to the next slide, one of the big areas where municipalities get themselves into a little bit of hot water is where we have, personnel and labor. Because as I indicated, the municipality and the board or the council is the final policy maker. So with that comes the decisions that need to be made regarding personnel and labor, hiring and firing. These are the big areas that, as policymakers, elected officials, sometimes you don't have the necessary understanding and background of what goes on. So as we start off, we'll start off by saying that Pennsylvania is an at-will employment state. So what does that mean? Well, what that means is that in Pennsylvania, you can be hired and or fired for basically any reason whatsoever. But you see in parentheses there, I have really. And the reason that I have that up there is because while that is the current state of the law, it's not 100% true, because there are so many exceptions to that at-will employment rule. And specifically, they deal with areas in which there is a claim of a constitutionally protected area or a constitutionally protected decision is made regarding hiring or firing. For example, you can't, and I mean, I know that this is pretty much common sense and everybody knows it, but I'll point it out just for the purposes of making the point. You cannot exclude someone from being hired. You can't fire somebody for any of the constitutionally protected areas, such as race, their sex, their sexual orientation, natural origin, religion, disability, any of those constitutionally protected areas. We cannot hire or fire someone based upon solely those decisions or those issues. There has to be a legally and cognizable decision that is outside of that. So that doesn't mean that, okay, well, anyone who comes in who has a disability, we have to hire. No, that's not it. For example, if you have someone who is disabled, they may not be able to meet the physical requirements to do the job, such as a police officer or a township laborer or something like that, based upon their disability. That doesn't mean that we can just automatically exclude them. What we have to do is we have to make a determination, and we have to go through the process of engaging in what's called the interactive process. And that interactive process is we have to look and see and understand what's the disability that you have, or what's the issue that you have as an employee, and can we accommodate that disability within your job description and otherwise, and your duties, to make it so that you can still do your job despite the fact that you have this disability. So that's covered under the Americans with Disability, the ADA Act. All of these things are also covered under the Civil Rights Act, for example, of 1964, and other federal laws and statutes that deal with these types of issues. So it's not quite as easy as at-will employment. We can hire and fire whatever we want. Before we take any type of disciplinary action or any type of action regarding employment status, I highly recommend that you deal with your solicitor and or your labor counsel in order to make sure that you are doing it in a way which is going to keep you out of litigation. Sometimes it's much easier, not sometimes, most times, it's much easier to take the time and handle these issues up front rather than doing it on the backside, when you're in a courtroom and a lawsuit has already been filed. In addition to that, there are also several administrative agencies which have been set up to deal with this type of issue. Specifically, we have the Pennsylvania Human Relations Commission here in Pennsylvania, as well as the Equal Employment Opportunity Commission under federal law. These are areas in which the individual can go to make a complaint without filing a lawsuit against the employer, to be able to have these issues addressed prior to going through the cost of litigation. So, as I said, at the bottom line with this is although we are an at-will employment state, there are a lot of exceptions that we have to deal with, dealing with these constitutionally protected areas. So before you make any type of hiring and firing decisions, you need to make sure that you're covering your bases, and do that through consulting with your solicitor or your labor counsel to ensure that you're complying with all of the specific areas that we've discussed. First Amendment, whistleblower, ADA, and all the other statutes and constitutionally protected areas that we have. Mike, anything you want to touch on with that, or should we move on to the next?
Yeah, so a lot of that to me, so I don't handle a lot of that stuff that we use. I use Andy and Chris and Sherry in our office, and Eric Brown when it comes to labor stuff. So a lot of it is a bit of a gobbledygook, really. But the most important takeaway from my perspective, and kind of wearing the solicitor hat, is make sure we know who is doing the hiring and firing, and when that is triggered, because oftentimes we see managers hiring people, and that's not to say you can't do that. You just need to know, as an elected official or as the person in the office, what is your ability to actually pull the trigger and hire somebody when you're sending letters to candidates that you've interviewed, and say you really like somebody and you send them a letter. How is that letter crafted so that if something comes up in a background check, you can appropriately back away from it? How do you deal with a situation where if you as a manager have that hiring and firing authority, hire somebody, and then the board doesn't like that person? What do you do next? Those are all things to think through and work through with your both your staff, your officials, and your legal counsel as to how you're going to approach it.
And Mike, those are great points. And just to touch on some of them quick, I know that we have municipalities, especially larger ones, where the board has a township manager or a borough manager, where it's so large that you can't rely upon having all the functions come to the board or the council itself. However, I really have to say that although your township manager or your borough manager may have hiring authority and firing authority, as many of them do, I would highly suggest that even if a manager has that authority, that they discuss it with council before they make those decisions, not only to cover on what Mike said, where, what happens if the township manager really likes this candidate, but the township board doesn't. So anytime that we're dealing with hiring or firing or making final decisions or decisions when it comes to disciplinary action that would result in suspension, termination, demotion, or loss of pay, any of those decisions I would suggest need to be run by and approved by the board or the council. And the reason for that is this. So even if the manager is acting with complete authority of the board, if the manager makes a decision that is contrary to any of these areas that we talked about, so where they potentially violate an individual's constitutional rights or constitutionally protected area, even if the manager has the authority to do it, the board's still going to be on the hook, because the board, they're going to come back and say, well, board, you designated or delegated this authority to the manager and they messed up. So you mustn't have trained them well. You mustn't have done something wrong because this manager didn't do it right and they made a mistake. So by sharing that communication back and forth on these types of important decisions, it really helps to make sure that everybody's on the same page, and also ensures that it's being done in a way that's proper. So my takeaway from that is, anytime that you're dealing with hiring, firing, or any type of discipline that involves suspension, termination, or any type of demotion or loss of rank, those things need to go before the board and have the board make a final decision. Now, if you have somebody who's coming in late, or minor types, counseling sessions, things like that, those types of things don't need to be brought to the level of the Board of Supervisors for a decision to be made. Obviously, your chief of police, your township manager, your supervisors can make that decision of the various departments, and they can move forward with it, so long as we have the proper policies and such in place. So when we talk about some of these unlawful unemployment practices that are listed there, again, we come back to that whole idea of, as a municipal policymaker, final decision maker, you need to understand what has happened in the past in order to be able to make lawful decisions in the current time. For example, if previously you have had an employee where a previous board has allowed them to do certain things, for example, they have been allowed to work from home on certain days, or they have been allowed to utilize vacation time for certain types of things outside of what would normally be considered vacation, or they've been given extra, things. And then you have another employee who comes in and asks for that. If there is any type of difference in those constitutionally protected areas, they can make what's called a desperate treatment claim. So, as I said, if you have a man that you've allowed to do one thing, and now you're trying to discipline a woman for the same thing, then they're going to make a desperate treatment claim, and that's going to be a problem for the municipality. So you need to understand what has happened in the past to make sure that you are doing the right thing currently, and that anything that has been extended or offered to a previous employee is extended or offered to another employee. The flip side of that is, you have to keep in mind that just because it sounds like it's a good decision right now for this employee to be able to offer them something or allow them to do something, you may then have to make sure that you do that for everybody else in the future. So because this employee is such a swell employee, and you want to make sure that they maintain that they're happy and that they stay on the job and everything like that, just make sure that you understand what you've done for one, you'll have to do for all in the future, potentially. So that's an important decision to make. Failure to make reasonable accommodations. We've kind of talked about that already under the ADA, where we need to make sure that we engage in that interactive process to make sure that we understand specifically what the needs are of the employee and be able to fulfill the essential job functions. And then we have taken steps to determine whether or not we can make a reasonable accommodation to allow that to take place. When it comes to reasonable accommodations, the municipality doesn't have to do exactly what the individual asks. They take into consideration certain things as cost, certain things as, does it provide does it create a type of hardship for the municipality to be able to allow for this type of accommodations. A lot of times when we see these types of accommodations, it's, well, I need, additional time off, or I only am able to work, half days, or I'm only able to come in for a few hours a day. And some positions, that's okay, that works. It's workable. Other positions, that's workable for a short period of time. And some positions, that's just not workable at all, because there's a need to be able to have someone fulfilling those essential functions of government in order to proceed. So it's not a one-size-fits-all type of accommodation that needs to be made. as I mentioned earlier, if this is where it's important to make sure that you have job descriptions and job functions in place that are current and actually indicate what the job functions and needs specifically are. Because what's going to happen is that's what a court or the Pennsylvania Human Relations Commission or the Equal Opportunity Employment Commission is going to determine or judge whether or not you have made reasonable accommodations for that individual. Because this is what their job function is, this is what they've asked to do, and this is why it would be a hardship for the municipality to allow for it, because they can't fulfill the essential job functions of the position, with the issue that they're currently having. So as we move back on to police, as Mike just changed the slide, this is exactly where we're talking about a lot of these issues come in. With a police department, there is a little bit of a difference when it comes to who is in charge, in the sense of it's not always the chief of police on certain things, but it is the chief of police on others. So an easy way to look at it is, if we're talking about knowing everybody's role and what it is. So if we're talking about a decision that needs to be made regarding a criminal investigation, criminal charges being filed, tactics, anything like that, I don't think that we want Joe the plumber, who is elected as one of the council members or township supervisors, being the one making those decisions, because they don't have any of the specific training and experience that your chief of police has. You hired your chief of police for their experience and their ability to do the job. When it comes to those types of decisions, let them do their job. Take their recommendations and let them do their job. Policymakers and elected officials should not be getting involved in what we like to call as behind the police tape. They shouldn't be injecting themselves into criminal investigations. They shouldn't be directing, investigatively, this is what we should do, this is what we should not do. And a lot of times elected officials have a tough time with that, especially in boroughs where we have the mayor, who under the borough code is the director or in charge of the police department, the day-to-day operations of the police department. We get an awful lot of rub between police departments, police chiefs, and mayors and councils in boroughs when it comes to that. So what is a board of supervisors or a mayor in charge of? Well, the way that I look at it in a borough is that borough council is in charge of setting what the policy is for the police department. What do they want to have done? What do they want to see? What's their vision? Those kind of things. It's the mayor's job to make sure that that council's policy and vision is put into effect within the department. And it's the chief of police's job to make sure that on a day-to-day operation, that policy and that vision is met by what's being done by the department and its actions. What we do where borough council or where the board of supervisors does have a role is in that administrative action that we've already talked about. Under the Municipal Police Tenure Act and the Borough Code, the council or the board of supervisors has the ultimate authority, which cannot be delegated to another, for any instance where there is, as I've said, any type of discipline that would result in termination of a police officer, suspension of a police officer, or demotion in rank of a police officer. So anytime you have one of those decisions being made or being contemplated, ultimately that decision has to be made by the Board of Supervisors. Hiring, firing of police departments, special discipline of police officers. As we said, there is a special conditions, considerations that we need to make there. Specifically, those are statutory, where we talk about Act 57 in a minute. But also, in addition to that, we have what's the collective bargaining agreement. Many of the terms under the collective bargaining agreement come into play when we talk about hiring and firing. In addition, there are special considerations under the Borough Code or the Police Tenure Act that allows for what needs to be done when hiring and firing and disciplining of a police officer. For example, under the Municipal Police Tenure Act, there are very specific instances where a police officer may be disciplined or terminated. And if you don't fit into one of those specific instances, then you really can't do it. So, obviously we're talking about neglect of duty, anything like that, the big ones that you would think. But when it comes to Pennsylvania being an at-will employment state, these are one of those exceptions that I was talking about. You can't just fire or discipline a police officer for anything. It has to be done in accordance with the Borough Code or the Municipal Police Jurisdiction Act, the Municipal Police Tenure Act, depending upon which one applies. Lastly, just as an update, Pennsylvania has Act 57, which was enacted in 2020, went into effect in 2021, and it now requires municipalities and police departments to do various pre-hiring checks for a police officer. It lists about 12 or 15 things that must be done before you can hire a police officer pursuant to the statute. And it also has post-termination requirements. Anytime that a police officer separates from you, if there is disciplinary issues or any type of what I call the 10 deadly sins that a police officer can commit, that information has to be reported so that when they apply for another job, the municipality understands and knows, what baggage that police officer may be carrying. Finally, with this, it's also important to know that there are specific rights with municipal employees that have to be met under the collective bargaining agreement, or if it's police officers or firefighters under the Municipal Police Tenure Act. For example, there are certain things that need to happen. There needs to be what's called a ladder mill hearing that needs to be held, where the employee has the ability to address the disciplinary or the allegations that are made against them. In the police department or the Police Tenure Act, there's also, in the Borough Code, there's certain restrictions that require time periods that have to be met. For example, after there's a ladder mill hearing, but before the borough or the municipality makes a decision on discipline or termination, a statement of charges needs to be presented 10 days before that decision is made. And then they have certain time periods to decide what election of remedies the officer may want to go through. So I mention these things to just keep them in mind, that it's not as easy as calling a police officer or an employee into your office and saying, hey, sorry, it hasn't worked out. We got to let you go. There are things that have to be met. So again, it's important to make sure that you're working with your solicitor or your labor counsel in order to ensure that you are walking through this minefield that exists, known as labor and employment. Mike, I'll turn it back to you. If there's any questions, again, hit them in that chat. We'll try to jump up, try to answer them as best we can.
So thanks, Andy. So jumping back to more of the mechanical day-to-day operations of us as a borough or a township, a couple of the things I wanted to point out, and I'm not going to read these verbatim or go through them in great detail, but obviously the big three for any new official or old official or even employees to make sure that they get a handle on. One is going to be the Sunshine Act, of course. And the key there is, number one, if there's any kind of official action being undertaken by a quorum of the board. So if there's a majority of the board or the council getting together to discuss or deliberate or debate whether the municipality should take a certain kind of action, it's got to be done in public. There are some exceptions. that would fit us under executive sessions, and they're laid out there. I'm not going to go through them in detail, but use as kind of your default that if we're going to talk about this as a body, as getting together as a group, we've got to do it in an open public session. The key things to remember in this, though, are number one, you as an official or a member are not limited to learning things at the public meeting. As Andy kind of mentioned earlier, the last time, our worst nightmare as your attorney is you as officials or the board learning something either the first time when you get sued or at a public meeting and being put on the spot to try to react to it in real time. That's not what the Sunshine Act requires. The Sunshine Act requires, if we're getting together as a group to talk about and debate and discuss this, we've got to do it at a public session. You're certainly free to learn information and gather info and kind of prep it to inform yourself before the meeting, and then you can raise those and debate those issues with the rest of the board beforehand. Second key point is official action cannot be taken in executive session. And this happens quite a bit with personnel discussions. When we go back and meet, we're talking about hiring or firing or disciplining someone. We still have to do that in public at a public meeting. And there are ways to do that, of course, but you can't just take a vote or a straw vote back in the executive session. Okay, good, we're good to go. We can move forward. Any kind of official action on that front still has to be taken at the public meeting. The other key issues with the Sunshine Act are ones that have come about a bit more recently. The key ones here in red are the newest ones. That is, we have to post the agenda at the municipal building 24 hours in advance of our regular board or council meetings. And if we have a website, we have to post it on the website 24 hours in advance. There are certain circumstances when we can make changes to the agenda, and a different additional vote has to be taken to do that. And it has to be posted the next business day if you do change the agenda. But these are all additional hoops that we have to jump through in kind of how we can't just willy-nilly and on the fly change things and take things up at the public meeting anymore, just because they come up to us. There are certain procedural steps we have to undertake if we want to do that. It's not impossible, but it's certainly something worth remembering. When these new requirements came out, a lot of us were quick on top of it to making sure that those agendas were being posted and all that kind of fun stuff. As we've gotten further away from it, we want to make sure that that's a reminder and that's fresh in everyone's brain, because the last thing we want is one of the actions that we've taken to be challenged because the agenda wasn't posted on the website before the meeting, or this particular item wasn't listed on the agenda and we didn't go through those steps to amend the agenda and post it after the meeting. And we go through all those details here in this slide, which is available afterward. I won't spend our time now going through it. Speaking of meetings, parliamentary procedure, everyone hears it, everyone knows about it. Hey, we've got to follow Robert's rules. Their dirty little secret is Robert's rules are not the law of Pennsylvania. There's nothing in the law that requires that we as a municipality follow Robert's rules. They're actually developed back after the Civil War by a former Civil War general. That's who Roberts was. And he was big into church and these different churches that he'd set up. And he'd have to go from church board meeting to church board meeting. And he was, as a former military man from the Civil War, he was frustrated with all the different approaches in terms of how people ran the meetings. And that's what developed the Roberts rules. They tend to be pretty complicated, pretty antiquated. And if you follow them to a T, they can really handcuff what you do as a municipal body. Most of us use the simplified approach, which is there's a motion made, a second to that motion, there's a discussion by the council and public comment period, and then you vote on it. And we can, of course, put all of our public comment front loaded at the beginning of the meeting, and then not have to necessarily take public comment on each particular action item if it's spelled out enough. But there does have to be a period of public comment under the Sunshine Act. For the voting requirements for the governing body, and only for the governing body, so the Board of Supervisors or Council, the vote must be approved by a majority of the entire governing body, regardless of the number that are present. So for example, if we have a Board of Supervisors that has 5 members and only 3 of them are there, whenever a vote comes up, all 3 of them have to vote yes for it. If it's a 2-to-1 vote, that doesn't pass because 2 is not a majority of 5. For other committees, so if you have a planning commission and the planning commission has that same number, 5 members, and there's only 3 of them there, and it's a 2-to-1 vote for a planning commission or an EAC or one of our other advisory boards, all they need is a majority of those people that are present. So if it's 2-to-1, it would pass. Public comments, some common questions that we often get. Do we need to allow it? Yes, we do. We can allow it either at the beginning of the meeting or at the end of the meeting, or the most conservative or open approach is we ask for it at each motion that's being made. Must we allow public comment on every action item? We do have to. Again, we can accomplish that in a sense through allowing public comment on any agenda items at the beginning of the meeting. The slight risk you have there is if your agenda is not detailed enough in terms of what action items you're going to undertake, there's always that risk that someone could say, well, I didn't have a reasonable period to make public comment because I had no idea what you were going to do. And I would have had comment and made and spoken about X, Y, and Z at the beginning of the meeting when you allowed it, but I had no idea you were going to raise taxes by 200% when you were approving the budget, or you're going to purchase new property when the agenda just said property matters. So there's different approaches, of course, and each municipality does a little bit differently, but we do have to allow some form of or period of public comment. Can we limit how long residents speak? The answer to that question is yes, except that when we do have restrictions in place on the amount of time that they speak, we prefer it, we want it in a written policy. And the toughest part of this is we have to apply that uniformly for everyone who comes up. So if there's that person who just complains all the time and they come to the meetings and all they do is complain, and we limit them to 3 minutes, and the next person comes up and they want to praise us for the good job we did at Community Day, and they take 4 minutes, we're going to be in trouble. And the person who complains all the time is going to claim, maybe rightfully so, that we violated their First Amendment rights by cutting them off at 3 minutes while allowing the person who's praising the board to go longer. Can we cut off a resident who speaks out of turn? Yes, there's parameters to do that. We typically have we have a pretty standard policy, a public comment policy that we've used and followed because of how tricky public comment, the First Amendment, and the Sunshine Act kind of all interplay. It's an issue you're going to need to make sure to take up with your solicitor. Do we need to answer questions? The answer to that is no. It's a public comment period. It's not a public question and answer period. Now I understand that's the legal response, that no, we don't have to we don't have to answer public questions. More of the political and the practical is if you want to avoid looking like we're just stonewalling people and shutting them down and ignoring them, it's probably good practice to respond in some way to their question, which could be, that's a great question, we're going to follow up with it, or here's the answer, or we disagree with you that that's even an issue. Abstaining from a vote, conflicts of interest in the Ethics Act. These are an individual obligation. So each official has the obligation to comply with the Ethics Act to avoid a conflict of interest. And if they are going to abstain from a vote, to do it in the appropriate way. So and there's different ways to abstain from a vote. For example, if someone misses a meeting and they don't want to vote on the minutes at the next meeting to approve that prior meeting, they can abstain from a vote, and that's not a conflict of interest. They can just abstain in the normal course and not vote because they weren't there. They had no idea what was discussed. However, if you're abstaining because you have a conflict of interest, the Ethics Act requires that you announce what the general reasons for that conflict of interest are, and you have to provide a written letter to the municipal secretary at or after the meeting to again spell out why you're abstaining because of a conflict of interest. Another key issue for any new official or old official to remember and know about is the Pennsylvania Right to Know Act. That was expanded in 2008. And the key takeaway from that is there is a baseline presumption that every municipal document is a public record. Now, there's a lot of different exceptions that are out there, but the one thing we like to drive home to everybody is if you're putting something in an email, if you're putting something in writing, make sure you're not going to be embarrassed about it if it ends up in the front page of the local newspaper, because that can happen. And either through right to know request or through litigation, that stuff can get out. So don't put things in writing or in email that you're going to regret later. No jokes. Don't forward jokes. That got some of the Pennsylvania Supreme Court justices in trouble about a dozen years ago. Be very circumspect and conservative in terms of what you put in writing and what you put out there, because it could all be discovered. Don't hide behind the idea that, okay, well, this falls in an exception to the Right to Know Act, so we don't have to give it out.
Hey, Mike,
other best practices.
Can I ask you a question about that? It's something that comes up all the time that we see that I think is important. So what about using, everybody uses technology now. So, what about using my personal email account to conduct municipal business? Is that a problem?
Yeah, so we recommend again, you can do it, but we recommend against it because one, if a right to know request comes in and you have information that would be considered a public record under the act on your personal email or your work email, you have to give it over. And as an example, kind of a nightmare scenario example, all the stuff as well is discoverable in litigation.
Yep.
And we had a piece of litigation. It was a 1983 substantive due process claim against a township. And one of the officials was using his his work email account for all township business. And when discovery came through, the other side wanted e-discovery, electronic discovery, and they ghosted. They had a computer forensic expert come in, and there were certain keywords that their emails were searched for, including their work emails. And he had to go to his employer, which was an international financial company, and explain to them, hey, by the way, that gig that I do on the nights and sometimes in the weekends for the township, where I'm a township supervisor and I'm not getting paid much, if anything, for it. Well, I was sued in it, and they need to come and search our financial email accounts for certain keywords of things that I might have been involved in. And he was transferred to Australia. So just because you're using it, your own personal account or a work account, doesn't shield it from not being a township or borough account. It's still going to be a township or borough account. The other thing not to do is don't intermingle social media accounts, because the law doesn't intermingle them either. There's a case out of Ohio where a Ohio County commissioner was blocking people from her Facebook page, which was so-and-so county official Facebook page, and it was found out that it was held by the court that she was violating that person's First Amendment rights by blocking them when they were making comment on her page about matters of public concern. So don't intermingle social media accounts either. And then, of course, again, no joke emails, and those always come back to bite you.
And same thing goes with text messages, right? If you text on your phone, all that good stuff, right?
Yeah, exactly.
Yeah. And just to touch on that as we talk about municipalities and litigation here, as we kind of wrap things up a little bit, that is huge when it comes to litigation. More and more we are seeing these e-discovery requests, especially in employment cases, where they're trying to figure out exactly what each individual knew at the time in which they knew it. So they've made these requests in a right to know scenario where, at least in these scenarios with litigation, you have some type of insurance coverage that may be covering the cost of litigation for you. When it comes to right to know, as most of you know, these are covered by the borough. It comes out of the municipality's budget. And the cost to have someone go through and review all of these emails in order to just determine, number one, what's relevant, or number two, what may be protected under the attorney-client privilege, or maybe some other type of privilege that you may have that can be invoked. Just the time and the cost is extraordinary. I've had clients in Lancaster County where you get one of these people who are these constant right to know people, and one of the municipal elected officials used her personal email account for everything, and we had to go through, and I mean, it was tens of thousands of dollars in order to be able to respond to what ultimately was a frivolous right to know request, but it still had to be defended and it still had to be reviewed. So I know that that's a pain. You like to have both of your emails and one email account and all that kind of stuff. I get it, but man, you'll thank us in the future if you ever get down this road of being sued. So it's funny, why do we get sued? If I knew the answer to that, I wouldn't be doing this. We get sued for everything. We get sued because somebody feels that obviously the municipality has done them wrong. My saying to that is, remember, anybody can file a civil lawsuit. It can be filed for everything. It doesn't even need to have a legal basis. Nothing can stop someone from filing it. It will be defended, and you may have great defenses, and you may be able to knock it out real quick, but nothing stops them from being filed. So remember that in what you're doing. We get sued generally, the municipalities will get sued in 3 different places. The first one is in federal court for, as we talked about, 1983 is the section of the federal statute that deals with constitutional violations. The individual is indicating or alleging that the municipality or one of its employees violated those rights, their constitutionally protected rights. And those constitutionally protected rights, when it comes to a police officer, could be, false arrest, excessive force, malicious prosecution. When it comes to employment, the employment arena, we have that, I was discriminated against based upon my sex, religion, whatever. I was discriminated against because I have a disability under the ADA. All those types of constitutional claims get handled in federal court. We can also get sued in state court for those exact same things under state law. In addition, that's where we also get the claims, as Mike said, regarding sidewalk, trip and falls, or roadway design, or land disputes, or planning, or any of those types of things. Those we see in state court. One of the big things to understand when it comes to federal court and state court is generally in federal court with most claims. And I say most claims because there are some exceptions, but most claims, especially those dealing with constitutional violations, there is a provision under federal law that allows for the recovery of attorney's fees, reasonable attorney's fees, in dealing with the litigation if the plaintiff is successful in showing a constitutional violation. So for attorneys, that is a big, as well as for litigants, that is a big thing to be able to get your attorney's fees paid for if you are a plaintiff. So most times we see individuals when they can moving to federal court for those types of constitutional claims for just that reason. So what do we do if we get sued, or who gets sued? Well, that's as I talked about earlier and alluded to, it depends. So the municipality itself is probably going to get sued. The individual employee or actor who is alleged to have violated the individual's constitutional rights, or whatever the claim may be, who had actual involvement, are going to get sued. But you, as the final policymaker, are also probably going to get sued. And when I talk with elected officials about this after a lawsuit's been filed, I don't know anything about this claim. I'm just a township supervisor. I don't have anything to do with the police department. I didn't arrest the guy. I didn't prosecute the guy. I didn't, allegedly use excessive force or tase the guy or anything like that. I'm just the supervisor. I don't know anything about this claim whatsoever. And it's like, well, yeah, but you're the policymaker. You're the boss. You're the one that's getting. You're on the hook. And it's important to recognize that as municipally elected officials, you can be sued in two ways. You can be sued in your official capacity, where it's for a decision that you made as an elected official, or perhaps a decision that you didn't make as an elected official. But you can also be sued in your individual capacity, in the sense of you had some type of direct involvement in the constitutional violations that took place, or the claims that made. And sometimes, depending upon how that direct involvement is, you need to be concerned as to whether or not the municipality is going to defend and indemnify you for those claims. For example, if there is a claim that you did something intentionally, you intentionally violated someone's constitutional rights in some way, shape, or form, then there is the potential that under Pennsylvania law, intentional acts of municipal employees are not covered, and they can be excluded from coverage. They can also be excluded from indemnification. So it's very important that you keep these things in mind when you're going through and being sued. In most cases, municipal officials don't act intentionally when doing something and violating someone's constitutional rights. So in most cases, they don't have to worry about that. But you need to understand that if you act intentionally and you intentionally violate, or it can be proven that you intentionally violated someone's constitutional rights, you could be on the hook, personally, for the cost of defense, as well as for any judgment that's entered against you. So that's very important. What do we do if we get sued? And this is a big one that we see. The biggest thing and the most important thing that you do is, once your department or your municipality receives any type of litigation, it be forwarded to your solicitor, and it also be forwarded to PIRMA. And the reason for that is, if you just sit on it and you wait, there are certain time periods that, as a defendant, we as defense counsel have to respond to allegations that are made. And sometimes the plaintiff's attorneys will not allow for extensions. And it takes time for the administrative staff at PIRMA to go through and process the claim, ship it over to our firm, and then we do our administrative role. So the more time that I have on the front end of being able to take a look and review the complaint and put together the potential defenses and meet with you or the individuals who are involved, get the necessary paperwork, policies, procedures, reports, and everything that you have, the more time that I had to do that on the front end, the better it is for everybody. So as soon as you get that notice of litigation, please reach out to PIRMA and your solicitor and let them know. In addition to that, if you have a large, if you have an incident where you think, oh boy, we could really get sued for something like this. Again, it doesn't hurt to have the municipality reach out to PIRMA to just let them know, because there may be some services in pre-litigation that we can provide for you. For example, as I said, I do a lot of police department work. We have clients through PIRMA whose officers have been involved in a serious use of force, where it is, an individual is shot, an individual is severely injured because of the action that a police officer took or didn't take. In those types of cases, even though no lawsuit has been filed, they contact PIRMA and we begin what I call a pre-litigation review, where we'll take a look at it and we'll start to take some steps to, number one, preserve evidence, make sure that evidence has been preserved so that we can properly defend. We'll do a review of the case, assist the municipality with a review, whether it be an internal affairs investigation or just a liability review of the case, in order to make a determination as to, okay, boy, everything was right, we have no issues here, or boy, we have some issues here. Maybe there's some steps that we need to take in order to mitigate potential damages or loss, as well as to make sure that in the future, if there's something that's not there, for example, perhaps the borough didn't have a policy on what was on this particular incident. The use of force policy needs to be updated to make sure that it's in compliance with current law. Then, we can certainly advise that and help out on that. So when these lawsuits come in, it's important to understand that this is something that generally takes a little bit of time. Most of the claims that are involved in these types of cases have a 2-year statute of limitations. So it's really important when you have those types of cases or incidents where you think, oh boy, we might be getting sued in this case, or that your policies and procedures make sure that you retain those types of records, what could be useful in the defense of those types of claims. For example, oftentimes I see claims where, 1 year and 11 months and 28 days, we get a copy of a lawsuit which is filed, and I go back and I say, all right, so they're claiming that excessive force was used by the officer in this case. Do you guys have body cameras? Do you have body worn cameras? Yeah, we do. Okay, great. Can you get me that body worn camera footage? Because man, that'll be great. We'll be able to take nothing better than showing exactly what happened, on film, on video. Yeah, we didn't preserve that. We only keep that for 60 days and then it gets written over. Well, you knew that the guy was severely injured, in this case. Didn't somebody think to, preserve that for litigation purposes? I mean, most times in those cases, criminal charges will have been filed, so it will have been preserved pursuant to the criminal case that's moving forward, but sometimes it's not. So again, it's important to keep these things in mind because there's many times at the state police where I've had these types of cases come up and, the call comes in and we want to sue you, we want to do this, we want to do that. And it's, okay, hold on, let me go get the video from it, I'll take a look at it. Oh, you guys have video of what happened? Okay, let me get back to you. And then we never hear back. So, all good there. But we've talked about the kind of claims. The litigation process takes a long time. We go through, initial answering the complaint to then discovery, getting all the facts, and taking depositions and all that kind of stuff to ultimately either some type of settlement, if appropriate, or ultimately through to the court process, through trial and appeal. It can be a long time is the point that I want to make. Just keep your patience and understand it. We've kind of gone through some of the common causes of actions. I just want to touch on the Monell claim because I mentioned it earlier. in a Monell claim, Monell is a theory under federal law that says that as the policymaker, you have a duty to do certain things. Specifically, you have a duty to make sure that policies and procedures are in place for your municipality to ensure that constitutional violations don't take place. So you need to have a use of force policy. You need to have a discrimination policy. You need to have a process for investigating these types of things, all that kind of stuff. Because not having that policy in place, you could claim that you are have a deliberate indifference on what's going on to these constitutional violations. The other two areas that we often see them in is failure to train. So we don't have a policy in place, we don't have proper training, especially for our police department, or when it comes to hiring of individuals. We didn't do a proper background check. We knew that, for example, this police officer had a proclivity to high-speed chases at his former department, but yet we hired him or her here, and then they got into a high-speed chase where somebody was seriously injured or killed. You should have known better, basically what they say. So those Monell claims come directly against the municipality itself. It's something, that's why we harp on you making sure that you have these policies and procedures in place. Mike, I know we're coming up close on time. Is there anything else you want to touch on regarding the litigation process?
Nope. And I think we're over on time, but
Okay.
I just want to say thank you to everyone for your time. We really appreciate it, and wish everybody Merry Christmas and Happy New Year, Happy Holidays, and look forward to seeing everybody in the new year.